Friends, yesterday the GST Council in its 31st meeting had very few agenda items. However, there were certain underlying facts on the basis of which decisions were taken. We are in this video going to analyze the underlying facts on the basis of which decisions were taken and the result and impact of those decisions on trade and industry. First, the issue relating to solar power generating systems and wind turbines valuation was referred to the Law Fitment Committee. Now, there is a history behind it. Solar power generating systems consists of around 70 to 75% in value of solar modules and batteries. 15% or so is the value of the accessories, and 10 to 15% is the value of the services of installation, commissioning, etc. However, initially all the advanced ruling authorities had held that the entire contract would be valued as works contract liable to 18% GST as services. However, representation were made by us to the Ministry of Finance and Commerce, and accordingly there was an amendment from 1st January 2019 whereby 70% of the value of the contract was deemed to be goods and 30% was deemed to be services, thereby making the composite rate on solar power generating system at 8.9%, which was also high. Now, Solar Developers Association approached the Delhi High Court and it claimed that actually 90% of the value, which is the fact, is actually goods and only 10% is the value of services. This valuation now has been referred by the Delhi High Court to the GST Council, and the valuation issue has now been referred to the GST Council to the Law Fitment Committee, which would give its recommendations in the next council meeting. Similar is the case whereby Indian Wind Turbine Manufacturers Association also approached the Delhi High Court, and the Delhi High Court also referred the matter to the GST Council, just like in the case of Solar Developers Association. Hence, now this valuation issue, which has been pending from the last 2 years, seems would be settled in a short period of time. Next is the case with lotteries. Now, in the case of Teesta Distributors and Others versus Union of India, the Calcutta High Court had held that lotteries were goods, they were actionable claims, and the taxation of lotteries under GST was not ultra vires the constitution. It also held that there can be dual rate in case of lotteries based on the destination principles and who sells it. Some states themselves opposed the rate and the destination principle. What was the rate and destination principle? There were dual rate in case of lotteries, 12% in case of intra-state sale by state government sponsored lotteries, and 28% in case of state government authorized lotteries by private agents, which can be interstate as well as intrastate. Certain states, in the case of Teesta Distributors only, had even opposed the dual rate and destination principle, although they had themselves been a party to the council decision passed by majority. Now, although the Calcutta High Court in the case of Teesta Distributors had held in the favor of revenue, yet because there was some anomaly within the states, therefore the matter relating to dual rate and destination principle in case of lotteries have been referred, the legal part of it have been referred to the Attorney General for its views. Friends, a major impactful decision taken in the council meeting is that new returns would be applicable from October 2019. For large taxpayers whose aggregate turnover, mind that the entire turnover pan India would be more than 5 crores, for them the new return ANX 1, the first part of the new return, would be applicable from October 2019. And for small taxpayers, for the quarter October to December, the new return would be applicable from January 2020. Hence, in hindsight, all the taxpayers, small or large, would require to amend their ERPs and the return filing system. The major impact on trade and industry would be that now the provisional credit which was available in GSTR 3B would be available only for 2 months. That is, for example, if you take the provisional credit of ITC on receipt of goods or services and you have to make a reconciliation supplier wise, invoice wise. If relating to those invoices, the supplier does not file his GSTR 1 or ANX 1 within 2 months and does not pay his taxes, then the recipient would have to reverse the input tax credit. There are various other elaborate provisions. Actually, in the new return, ANX 1 is qua GSTR 1, ANX 2 is GSTR 2, and RET 1, the main form, is GSTR 3. Hence, we should be ready with our ERPs to take up the new returns, which include elaborate provisions. Now, in the new returns, one has to give invoice-wise details of import of goods, invoice-wise details of import of services, invoice-wise details of receipt of goods from SEZ. Hence, much more elaborate systems are required as per new returns, for which trade and industry should now prepare itself. There are various welcome extensions. GSTR 993 and ITC 4 have been extended till 31st of August. Rule 138E of the CGST Act, whereby in case a supplier does not file his returns for 2 months, he would be barred from making way bills, is extended till 21st of August. And the option to avail composition scheme for service providers, the date of taking the option has been extended till 31st of July 2019. Hence, there are various underlying facts in this GST Council which would impact trade and industry and should be taken note of. In going forward now, we understand that the GST authorities would take strong action against tax evaders, and so that the tax collection is improved. And hence, this council meeting also has paved the way for e-invoicing from January 2020. Therefore, we should now give due compliance much more than previously to the compliances as per GST Act. Thank you very much.